Welcome back to the deep dive. You know the drill. We take the sources.
And boil them down. Cut right to the chase.
Exactly. So you get the essentials fast.
And maybe find a few aha moments, too.
Today, it's bankruptcy, a big topic, right?
Yeah.
Specifically, how it works in the U.S. courts.
Yeah, we're digging into the official guide from the courts themselves, Bankruptcy Basics.
So our mission, really, is just to unpack that. What is bankruptcy? According to them, what are the main types?
The key stuff you need to know.
Consider it your kind of quick guide to the fundamentals.
Getting the big picture, straight from the source, without, drowning in jargon.
Okay, let's get into it. So foundationally, what is bankruptcy based on this source?
Well, the publication calls it a legal procedure, court-supervised, designed specifically to help people, and businesses too, deal with serious debt problems.
Okay. And there's this term, discharge. Sounds really important.
Oh, it's central. Absolutely. The source defines the discharge as a permanent court order, and what it does, essentially, is release the debtor, the person filing, from being personally liable for most debts.
Personally liable.
Yeah.
So if a debt gets discharged, the creditor just can't come after you anymore for that specific debt.
That's the idea. The order explicitly stops creditors from taking any kind of collection action on those discharged debts. Phone calls, lawsuits, they have to stop. It's meant to be a fresh start.
Wow. That sounds incredibly significant. But the source has a pretty big but here, doesn't it? It's not a total magic wand.
Exactly right. Your personal liability might vanish, but the source is clear. A discharge typically does not wipe out a valid late on property.
A late. Okay, what does that actually mean for someone?
Think of it like this. If you put up collateral for a loan, say, for a car loan or your house for a mortgage, the lender's right to that specific property usually stays intact. Even if you don't owe the money personally anymore, if you stop paying on that loan, they might still be able to take the collateral. The lien gives them that right.
Ah, okay. So the debt's gone for you, but their claim on the thing might not be.
Got it. Precisely. And the publication says there are 6 basic flavors of bankruptcy cases named after the chapters in the Bankruptcy Code.
6 types. Okay, where should we start?
Let's begin with Chapter 7. It's often referred to as liquidation.
Liquidation. Sounds like selling things off. What's the main goal?
The idea behind Chapter 7 is this orderly process. There's a court, there's a trustee overseeing things. The trustee's job is to gather up any assets the debtor owns that are not exempt.
Not exempt. Wait, so you do get to keep some things?
Yes, definitely. That's a crucial point. The law protects certain property that's your exempt property. What exactly is exempt can depend on federal rules or your state's laws. The trustee is only interested in the non-exempt stuff.
And practically speaking, do most people filing Chapter 7 have a lot of this non-exempt property?
Actually, no. The source points out that in the vast majority of individual Chapter 7 cases, there's very little or even zero non-exempt property to sell. These get called no-asset cases.
No-asset cases. So if there's nothing to sell, do creditors get paid anything?
In those no-asset situations, unsecured creditors, think credit cards, medical bills, usually get nothing. There's just no money to distribute. If it is an asset case, meaning there is non-exempt property sold, then unsecured creditors might get something, but only if they file a proper claim form with the court by the deadline, usually about 90 days.
Makes sense. And who typically files Chapter 7?
It's mainly set up for individuals. Businesses like partnerships or corporations can file Chapter 7, but they essentially cease to exist afterwards because all their assets get liquidated.
Okay. And the discharge we talked about, how does that work in Chapter 7?
For individuals, this is often the main draw. You get that discharge, wiping out personal liability for most debts relatively quickly. The source says usually just a few months, maybe around 4 months after you file the initial paperwork.
4 months, that's pretty fast. But I remember hearing about a means test. The source mentions this came in with a 2005 law.
That's right. The means test is basically a screening tool. It's designed to see if an individual consumer debtor filing for Chapter 7 really needs liquidation, or if they actually have enough income to potentially pay back some of their debt through a Chapter 13 plan instead.
How does it screen them?
It starts by comparing your average income over the last 6 months to the median income for a household of your size in your state.
And if your income's higher than the median?
Then the test gets more detailed. It looks at your specific income and subtracts certain allowed expenses to figure out if you have enough disposable income left over each month. If that disposable income is above certain thresholds, enough to pay a meaningful amount to unsecured creditors over 5 years, then the law presumes that filing Chapter 7 would be an abuse.
Abuse. So what happens then?
Well, unless you can prove there are special circumstances, maybe a sudden job loss after the test period, a serious illness, being called to active military duty, things that genuinely affect your ability to pay, then you likely won't qualify for Chapter 7. The court might dismiss your case or push you towards converting it to Chapter 13.
Okay, so the means test tries to route people who can pay something towards a repayment plan.
That's the fundamental idea behind it, yes.
So, Chapter 7, liquidation, quick discharge, but mainly for those who pass the means test, often with fewer non-exempt assets. The source says there are other paths too.
Oh, absolutely. Bankruptcy isn't the only answer. There's Chapter 13, which we'll get to, Chapter 11, reorganization, and even non-bankruptcy options like working with a credit counselor or trying to negotiate directly with creditors.
Right, so actually doing Chapter 7, what's involved, what info do you need to give?
It's pretty thorough. You start with the main petition document. Then you have to file detailed lists. These are called schedules, showing all your assets, all your debts, your income sources, your monthly expenses. Plus, a statement about your financial history, any existing contracts or leases, copies of recent tax returns. Oh, and proof you took a mandatory credit counseling course before you filed.
Wow, okay. That is a lot. Are there costs? Fees?
Yes, there are filing fees, administrative fees, adds up to a few $100s. The source does say you can often ask to pay them in installments. And if your income is very low, below certain poverty guidelines, you might even qualify for a fee waiver from the court.
And once you file all that, there's some kind of meeting.
Correct. It's usually called the meeting of creditors, sometimes the 341 meeting from the code section. It typically happens 20 to 40 days after you file. And you have to go.
What's that meeting like? Is the judge there grilling you?
No, actually, the judge isn't allowed to attend. You meet with the Chapter 7 trustee who's appointed to administer your case. Any creditors can also show up and ask questions, although often they don't for individual cases. You're put under oath, and the trustee will ask you questions about the information in your petition and schedules, about your property, your debts, the consequences of bankruptcy, things like that.
No judge. Why not?
The source explains it's to keep the judge impartial. The judge needs to be able to rule fairly on any disputes that might come up later, so they stay out of this initial fact-finding meeting.
Okay, so the trustee runs that meeting. Is getting the discharge automatic after that, assuming you filed correctly?
Not quite automatic. It's the standard outcome if everything's in order, but it's not an absolute right. The trustee or a creditor or another official called the U.S. trustee can actually object to your discharge.
Object? On what basis?
The law lays out specific reasons. Usually, it involves some kind of dishonesty or failure to cooperate. Things like hiding assets, destroying financial records, lying under oath, not being able to explain what happened to assets, disobeying a court order, failing to provide requested tax documents. Also, if you got a discharge in another bankruptcy case too recently, that could block a new one.
And if someone objects?
They have to file a formal complaint with the court. This starts what's called an adversary proceeding, basically, a lawsuit within the bankruptcy case to determine if the discharge should be denied. The person objecting has to prove their case.
You mentioned reaffirming debt when talking about the trustee's questions. What does that mean?
Right. So a reaffirmation agreement is basically a new contract you make with a specific creditor during your bankruptcy. You agreed to remain legally responsible for that debt even after you get your discharge.
Why would someone do that?
Usually it's to keep property that secures the debt. The most common example is a car loan. If you want to keep the car, you might need to reaffirm the loan, agreeing to keep making the payments.
Is it just up to you and the creditor?
Mostly. But there are safeguards. The agreement has to be in writing, signed before the discharge, filed with the court, and contain specific disclosures about what you're agreeing to. And sometimes the court has to approve it, especially if you don't have an attorney or if your budget makes it look like the payments would cause you hardship. If you do have an attorney, they have to certify it won't cause hardship.
And the source also says you can just pay voluntarily.
Yes, that's always an option. Even if a debt is discharged, nothing stops you from voluntarily making payments later if you want to, without signing a formal reaffirmation.
Okay, Chapter 7 recap. Keep exempt stuff. Trustee might sell non-exempt stuff. Get a fast discharge usually, unless someone successfully objects or you choose to reaffirm certain debts. But even with a discharge, some debts just don't go away, right?
That's absolutely crucial to understand, yes. The Bankruptcy Code lists several categories of debts that are generally non-dischargeable. Policy reasons mean they survive the bankruptcy.
Like what? Give us some big ones from the source.
Well, top of the list are things like most recent taxes, domestic support obligations, alimony, and child support debts for causing death or injury while driving under the influence. Most student loans are notoriously hard to discharge, and debts from willful and malicious injury you caused to someone else or their property. Also, debts you forgot or chose not to list in your paperwork usually aren't discharged.
What about debts from, say, lying on a credit application? Fraud.
That's an interesting category. Debts obtained by fraud or embezzlement or similar bad acts. The source says these can be discharged unless the creditor takes action. The creditor has to file one of those adversary proceedings in the bankruptcy court on time and prove to the judge that the debt fits the legal definition of non-dischargeable fraud. If the creditor doesn't do that, the debt is discharged along with the others.
So for those types, the creditor has to fight for it. It's not automatic exclusion.
Exactly. Some debts are just non-negotiably excluded. Others require the creditor to step up and prove their case.
Okay, that's a helpful picture of Chapter 7. Let's switch over to Chapter 13. The source calls it adjustment of debts of an individual with regular income. Sounds very different from liquidation.
It really is. Chapter 13 is geared towards individuals who have a reliable source of income. The core idea is you propose a plan to repay some or all of your debts over a period of time, usually 3 to 5 years. It often lets you keep key assets, like your house or car, that might be at risk in Chapter 7.
So you're paying over time instead of selling things off now.
That's the main distinction, yes. You develop a budget, figure out your disposable income, and make regular payments to a Chapter 13 trustee. The trustee then distributes that money to your creditors according to the terms of your court-approved plan. It's also the chapter people end up in if the means test blocks them from Chapter 7.
Who can file Chapter 13? Any income limits or debt limits?
You need to be an individual, no corporations or partnerships, and have regular income. That can include self-employment or running a small, unincorporated business. There are debt limits, though. Your unsecured debts, like credit cards, medical bills, and your secured debts, like mortgages, car loans, have to be below certain amounts set by the law. These amounts get adjusted periodically, but currently, unsecured is under roughly $360,000, and secured is under about $1.1 million.
Any other bars to filing?
Yeah, similar rules as Chapter 7 apply if you had a prior bankruptcy case dismissed within the last 180 days for certain reasons, like ignoring court orders or voluntarily dismissing after a creditor asked for relief from the stay. And again, that pre-bankruptcy credit counseling requirement usually applies. Must be done within 180 days before filing.
How does it start? Similar paperwork.
Pretty much the same initial filing package as Chapter 7, the petition, all those schedules of assets, debts, income, expenses, statement of financial affairs, proof of credit counseling, tax returns, and so on. Filing fees are similar too, and again, installment payments are possible.
Does the automatic stay kick in here too?
Oh, absolutely. Filing Chapter 13 immediately triggers the automatic stay, stopping most lawsuits, wage garnishments, foreclosures, repossessions, and the source mentions a special feature in Chapter 13. It often protects cosigners on your consumer debts too, which Chapter 7 generally doesn't.
And you mentioned saving a house. How does that work?
It's a very powerful tool for that. The stay stops the foreclosure process immediately. Then, your Chapter 13 plan can include provisions to catch up on the missed mortgage payments, the arrearages, gradually over the 3 to 5 years of the plan. You do still have to make your regular ongoing mortgage payments as they come due after you file, though.
Okay, file. Stay happens.
Yeah.
Is there a meeting of creditors, like in Chapter 7?
Yes, there is. Same setup. Usually within a month or two, you have to attend. The trustee and any creditors who show up will ask questions focusing not just on your finances, but also on your proposed repayment plan. And again, no judge attends this meeting. Creditors wanting payment under the plan need to file their proof of claim.
Right, the plan. That's the key part of Chapter 13. What has to be in it?
You propose how you'll make payments to the trustee, usually monthly. The trustee takes that money and pays creditors based on the plan's terms.
How long do these plans last?
Depends on your income. If your current monthly income is less than the median income in your state, the plan typically lasts 3 years. If your income is at or above the median, it generally must be 5 years. It can't go longer than 5 years, though.
Are there rules about who gets paid what in the plan?
Definitely. The source lays out requirements. Priority debts, think recent taxes, domestic support generally have to be paid in full. If you want to keep property securing a debt, like a car, the plan has to pay the creditor at least the value of the collateral over the plan's life, maybe the full amount if it's a newer loan. And like we said, mortgage arrears can be caught up over time.
What about regular unsecured debts, credit cards, etc.?
Yeah.
Do they get paid in full?
Not always. This is a big point. Your plan doesn't necessarily have to pay unsecured creditors 100 cents on the dollar. Two key tests apply. First, you generally have to commit all of your projected disposable income for the entire length of the plan, 3 or 5 years. Second, whatever the plan does pay unsecured creditors has to be at least as much as they would have received if you'd filed Chapter 7 instead. That's the best interests of creditors test.
Disposable income. How's that defined here?
The source describes it as your current monthly income minus amounts that are reasonably necessary for your support and your dependents' support. It also allows for deducting things like ongoing charitable contributions up to a limit, and if you run a business, ordinary operating expenses.
Okay, so the plan balances paying what you can afford, disposable income, with certain minimum payment rules. Does a judge need to approve this plan?
Yes. After the meeting of creditors, there's a confirmation hearing. The judge reviews the plan to make sure it meets all the Bankruptcy Code's requirements, that it's feasible. You can actually make the proposed payments, that you proposed it in good faith, and that it satisfies those payment rules like the best interests test. Creditors get notice and can object if they think the plan falls short.
And if the judge confirms it?
Then it becomes binding. You're locked in to making those payments to the trustee for the plan's duration. You live on your budget. The source notes you generally need the trustee's okay to take on significant new debt while you're in the plan. And sticking to it is crucial. Falling behind on payments or not paying ongoing support or taxes can lead to the case being dismissed or converted to Chapter 7.
When do you get the discharge in Chapter 13? Is it quick like 7?
No, that's a major difference. In Chapter 13, you don't get the discharge until after you've successfully made all the payments required under your confirmed plan. So typically 3 to 5 years down the road.
And is the discharge itself different from Chapter 7?
The source says it's generally broader, yes. It wipes out your liability for most debts that were provided for in the plan or were disallowed by the court.
Most debts. So there are still exceptions.
Yes, some debts still survive Chapter 13. The source lists things like long-term secured debts where the final payment is due after the plan ends, like a mortgage, alimony and child support, certain taxes, most student loans, DWI debts, and criminal fines or restitution. Those generally aren't discharged.
What about those debts from fraud or malicious injury, the ones where a creditor had to object in Chapter 7?
This is where the Chapter 13 discharge can be more powerful. Debts that would require a creditor lawsuit to be declared non-dischargeable in Chapter 7, like garden variety fraud, fiduciary defalcation, or even willful and malicious injury to property, which is usually non-dischargeable in Chapter 7, can potentially be discharged in Chapter 13 if the creditor doesn't file that adversary proceeding and win. However, debts for willful malicious injury to a person resulting in injury death still require the creditor action to survive discharge, similar to Chapter 7.
Interesting. So completing a Chapter 13 plan might clear certain debts related to past conduct that Chapter 7 wouldn't, but the big categories like support and taxes still stick around.
That sums it up well. There's also a mention of a hardship discharge in Chapter 13. If something totally unforeseen and outside your control prevents you from finishing the plan, and creditors got at least what they would have in Chapter 7, and modifying the plan isn't feasible, the court might grant a hardship discharge. But its scope is narrower, more like a Chapter 7 discharge.
Okay, Chapter 7 liquidation, Chapter 13 individual repayment. What about Chapter 11? The source calls it reorganization, often linked with businesses.
That's its primary use, definitely. Chapter 11 allows businesses, especially larger ones, to keep operating, restructure their finances, and propose a plan to pay creditors over time, hopefully emerging as a healthier company.
Can individuals use Chapter 11?
They can, yes. It's generally much more complex and expensive than Chapter 7 or 13, but it's an option, particularly for individuals with very high debts exceeding the Chapter 13 limits or with complex business affairs. Similar pre-filing rules about prior dismissals and credit counseling apply.
How does it work differently for a business, say?
A key feature is the debtor in possession concept. Usually, the existing management continues to run the business and control its assets during the case. A trustee isn't automatically appointed like in Chapter 7 or 13. That only happens if there's a specific reason, like fraud or serious mismanagement.
And the debtor proposes the reorganization plan.
Typically, yes. The debtor usually has an exclusive period, initially 120 days, extendable to file a plan. This plan categorizes creditors and equity holders into classes and details how each class will be treated. They also have to provide a disclosure statement with enough information for creditors to vote intelligently on the plan.
Creditors vote.
Yes, creditors whose claims are impaired, meaning their legal rights are being altered by the plan, get to vote. For the plan to be confirmed by the court, it generally needs approval from classes representing a certain amount of the debt.
What's the judge looking for at confirmation?
The court has to find the plan is feasible, likely to succeed, not lead to another bankruptcy, that it's proposed in good faith, complies with the code, and treats creditors fairly according to legal standards. Sometimes a plan can be confirmed even if a class votes no, through a process called cram down.
And the discharge in Chapter 11, when does that happen?
For business entities like corporations or partnerships, confirmation of the plan usually acts as the discharge for most pre-confirmation debts. But for an individual filing Chapter 11, it's different.
For an individual?
Well, first, an individual in Chapter 11 is not discharged from those specific types of debts listed in Section 523A, the same ones generally non-dischargeable in Chapter 7, taxes, support, fraud, etc. Second, similar to Chapter 13, an individual usually doesn't receive their discharge until after they have completed all payments under the plan. And if the plan is essentially a liquidation plan for the individual, they only get a discharge if they would have qualified for one in Chapter 7 anyway.
So for an individual, Chapter 11 feels like a mix. The types of debts discharged are like Chapter 7, but the timing of the discharge is often like Chapter 13, after payments. Seems really geared towards complex situations.
That's a fair takeaway. The source also mentions things like creditors' committees, which play an oversight role, special streamlined rules for small business cases, and the power for the debtor or trustee to pursue avoidable transfers, clawing back certain payments made just before filing that unfairly preferred one creditor over others.
Like paying off a loan to your brother right before you file.
That could potentially be one example, yes. Or large, unusual payments to suppliers outside the ordinary course of business. The goal is fairness to the overall creditor body.
Okay, so 7, 13, 11 are the main ones. The source briefly touches on a few others too.
Right. There's Chapter 12. It's specifically designed for family farmers or fishermen.
Very specific.
It is.
It's
Structurally, it's a bit like Chapter 13 involves a repayment plan over 3 to 5 years with a trustee. But the eligibility rules are very specific, tied to debt limits and percentages of income derived from farming or commercial fishing operations. Discharge comes after completing the plan, similar exceptions to Chapter 13.
And Chapter 9.
Chapter 9 is unique. It's for municipalities. Think cities, towns, counties, school districts, public utilities.
Can creditors force a city into bankruptcy?
No, the source is clear. Chapter 9 must be a voluntary filing by the municipality itself. It respects state sovereignty. The municipality generally stays in control of its operations and develops its own plan to adjust its debts.
Does the automatic stay protect a city?
Yes, and it extends protection to its officers and residents regarding certain municipal taxes or assessments. Confirmation requires court approval, potentially creditor votes, maybe crammed down. Discharge follows confirmation and plan implementation.
And lastly, Chapter 15.
Chapter 15 tackles cross-border insolvency. It's based on a UN model law and provides rules for coordinating bankruptcy or insolvency cases when a debtor has assets or creditors in more than one country.
So for international situations.
Exactly. It aims to promote cooperation between U.S. courts and foreign courts, provide predictability for international trade, protect assets, and help rescue multinational businesses. It allows foreign representatives to access U.S. courts.
Interesting. Okay. Shifting slightly, the source also mentions some related laws that offer protection, like the Servicemembers Civil Relief Act, or SCRA.
Yes, the SCRA is a really important federal law. It provides various legal protections for active duty military personnel to prevent them from being penalized in civil court matters, including bankruptcy, while they're focused on their service.
How does it help in bankruptcy specifically?
The source confirms it applies. For example, it provides safeguards against default judgments if a service member can't respond to a lawsuit or bankruptcy matter because of their duties.
What else does it do?
It allows service members to request a stay or pause in proceedings if military service materially affects their ability to participate. It can also offer protection against things like eviction without a court order, allow for terminating leases upon deployment or transfer, and sometimes these protections extend to dependents or co-signers.
A vital protection. What about SIPA, the Securities Investor Protection Act?
SIPA is very specific. It deals with failed brokerage firms. The Securities Investor Protection Corporation, SIPC, was set up to handle these situations.
Protecting investors' accounts.
Exactly. If your brokerage firm fails, SIPC steps in. They try to transfer customer accounts to a stable firm or oversee a special liquidation process. The key is, SIPC works to return the cash and securities held in customer accounts, protecting up to $500,000 per customer for missing assets.
And this replaces a normal bankruptcy for a broker.
Generally, yes. A SIPA liquidation is its own specific proceeding under that act, handled by a SIPA-appointed trustee. It usually takes precedence over a standard bankruptcy filing for a brokerage.
It really shows how specialized the law can be. Okay, let's pull back and maybe recap some big ideas that seem to run through most of these bankruptcy chapters, according to the source.
The automatic stay is definitely number one. That immediate halt to most collection efforts right when the case is filed. It creates that crucial breathing spell.
Gives people space to figure things out.
Precisely. Though creditors can ask the court to lift it in some situations.
And we've hit this hard, but non-dischargeable debts are key to understand.
Absolutely critical. That fresh start doesn't mean everything disappears. Certain debt support, recent taxes, student loans, debts from bad acts are generally preserved by law no matter the chapter.
Also, creditors aren't just passive bystanders. They can file objections.
Right. They can object to the discharge itself in Chapter 7, or object to how their claim is treated, or whether a plan should be confirmed in Chapters 11, 12, or 13. They have a voice.
Which might lead to those mini lawsuits within the case.
The adversary proceedings, that's how specific disputes get formally resolved, like whether a debt is dischargeable or whether a pre-bankruptcy payment can be recovered.
And lastly, that protection against discrimination.
Yes, that's important for the fresh start concept. The law generally forbids government entities and private employers from discriminating against someone just because they filed bankruptcy or had debts discharged.
So filing shouldn't automatically cost you your government job or license, for instance.
Correct. It aims to prevent people from being penalized solely for using the legal debt relief system.
Well, we have certainly covered a lot of ground from the Bankruptcy Basics publication. We've gone from Chapter 7 liquidation through Chapter 13 repayment, Chapter 11 reorganization, touched on 12, 9, and 15, and looked at SCRA and SIPA protections.
Yeah, it paints a picture of a complex system with different tools for different situations, whether it's an individual needing a reset, someone using income to save assets, or a business restructuring. Understanding those core ideas, the stay, discharge, non-dischargeable debts, LINs, is really fundamental.
Having this foundational knowledge straight from the court's own material is so valuable if you or someone you know is grappling with financial hardship, or even just trying to understand how this part of our legal system works.
It really underscores the balancing act involved creditor rights versus debtor relief.
Exactly. So let's leave you with this final thought to chew on. Considering everything we've unpacked today, the power of the automatic stay to halt collections, the potential finality of the discharge releasing personal liability, the structured ways to repay over time, what does this whole system, as outlined by the U.S. courts, really tell us about how American society values the idea of a second chance, a fresh start for individuals and businesses, even when that inevitably affects those who are owed money?